Hi everybody, my name is Neil Thompson. I am a patent agent and you're probably wondering why I am making this video. I've been a follower of Dr. Boyce Watkins for quite some time now, at least a year, and I was listening to one of his Facebook live streams and someone had asked a question about the process for getting a patent. And since I'm a patent agent, I thought this would be a good opportunity to make a video about the process of getting a patent. Some people, when they find out that I'm a patent agent, they ask what's the difference between a patent agent and a patent attorney. And the main difference, well, really the only difference, is law school. Attorneys obviously have gone to law school and have passed the bar in a state, which makes them attorneys. But when it comes to actually drafting, filing, and prosecuting patents within the U.S. Patent Office, both patent agents and patent attorneys have that ability. And so as a patent agent, I can take someone's invention idea and turn it into an application, file it with the patent office, and then be the go-between between the patent office and the inventor to hopefully get the person's invention turned into a issued patent. One thing that I think I really should mention before I go into the actual steps in getting a patent, people often have the misconception that once you apply for a patent, it's just a matter of time before you get it. And that's unfortunately not true. Just because you apply for a patent doesn't mean that you're going to get it. And it really stems from the actual definition of a patent. A lot of people think a patent gives you the right to make your invention when actually a patent gives you the right to exclude others from making your invention. You may wonder what the main difference between the two of those is, and essentially what it comes down to is patent infringement. It's possible to have a patent that infringes on someone else's patent. Before I became a patent agent, I worked in medical devices as an engineer for a number of years, and the companies that I've worked for were involved in patent infringement suits. A company would sue them for patent infringement, saying that a claim in their patent was infringing on a patent that they had, and oftentimes it would end up in being settled, and in some cases even going all the way to court. And at least for one of the companies that I worked for, they were on the losing end of a court battle involving patent infringement and had to pay royalties to this other company on a product that the company that I was working for was selling. And so I just want to reiterate, just because you apply for a patent doesn't mean that you're going to get it. And then another thing I want to mention is just because you get a patent, that's not the end all and be all. Yes, you have a patent and that's great, but then what? What are you going to do with this patent? What people tend to want to do is make some sort of money off of it. And that may be, you have your patent and then you want to design and actually sell your invention, or maybe you want to license it to another company. Maybe you want to sell the technology, the IP, to another company. And these are all things that you really need to take into account before you even go down the path of applying for a patent. And the reason for that is patents are expensive and it takes a while to get. Typically, if you're on average, it can take up to 3 years to actually get a patent. And not only that, but there are a lot of fees that are involved. And I'll actually go through the fees that are involved in getting a patent, both the patent practitioner fees, that when I say patent practitioner, I mean either a patent agent or a patent attorney, and also the fees that you're going to be paying the patent office, and there's quite a number of them. So first things first, if you have an invention idea, what you really want to do is do your own search, and you can do that using Google Patents, or you can go on Free Patents Online or freepatentsonline.com and do your own search on the patents that have been issued already, and then also patent applications that have been filed. And you can do that on your own, and basically you're looking for inventions that are similar to your own, and by doing that you make your hopefully you'll be able to come to a conclusion on whether it's even worth it for you to go ahead and go down this whole path of applying for a patent. Once you've done that and you found that you haven't really found anything that's like your invention, then the next thing you would want to do is get in contact with a patent practitioner, either a patent agent or a patent attorney. And typically what they'll have you do is fill out what they call an invention disclosure form. Essentially, it's telling the person or the patent practitioner what your invention is, how it's different from other inventions that are out there. hopefully you have some sketches of what your invention is as well. Basically fleshing out as much as you possibly can your invention idea. And then after you fill out this invention disclosure form and send it back to the patent practitioner, then they're most likely going to recommend you have a professional prior art search done. So yes, you've done your own search, but then by having a professional search done, typically those search companies have access to databases that you as a lay inventor don't. And so they're most likely able to come back with even more inventions, patents and issued patents and applications that you weren't able to find in your own search. These typically cost about $500 to have a prior art search done. When you have the results from that patent search, then the patent practitioner is going to issue you what's called a patentability opinion. Essentially, they're going to go through all of the documents that the patent search company was able to find, and they'll give you their opinion on, based on those documents, whether they think you have a good shot at getting a patent. Now you also again have the opportunity to really think about whether this is worth going down this whole path. So right at this point, you've spent about $500 for the prior art search. You get this opinion from the patent practitioner, and as I said, now you have again another opportunity to think, is this worth pursuing getting this patent? The next thing you really have to decide is the actual application you're going to decide. That's, of course, if you've now decided that you're going to continue on with getting a patent, now you have to really figure out what kind of patent do I want to get. Essentially there are two types of patents, and then there's what's called the provisional patent, which ties to one of the other patent applications. So I'll talk a bit about the provisional application first. So essentially a provisional application is what people tend to want to file if they're still kind of unsure on whether they want to tackle all those costs that are basically coming down the pike. Provisional application is good for a year after filing it, and within that year you have to determine whether you want to file what's called a utility application. So the provisional application, what is often recommended, is you want to file that provisional application before you publicly disclose your invention to anyone. And I just want to say that talking to a patent practitioner about your invention does not count as a public disclosure, and neither does filing the provisional application with the patent office. What does count as a public disclosure is offering to sell your invention to others, publishing it in a peer-reviewed journal article, just talking to other people about your invention, but at least without having a non-disclosure agreement signed between yourself and the people you're talking to. So it's always recommended that you file a provisional before you publicly disclose to anybody. So that's one thing. Another thing about provisionals is that this provisional has to fully support the utility application that you will eventually file in the year. And the reason for that is if it doesn't, then you will not, you run the risk of not being given or not being granted the filing date of that provisional application. So here's an example. Say you file a provisional application on January 1st, 2016. So you have until January 1st, 2017 to file the utility application. So you have that year. If your utility application has different subject matter than that provisional application you filed in 2016, you will not get the filing date of January 1st, 2016 as the filing date of your application. You'll get the date January 1st, 2017. And you may think, what's the big deal? Well, essentially you wasted your time filing that provisional application and the money if you added different things afterwards. So you really want to make sure that what's in your utility application matches with what's in your provisional application. And as I said earlier, you have a year after filing the provisional application to determine whether you want to file a utility application or not. So I guess this leads into what a utility application is. So a utility application is an actual application as opposed to a provisional, which kind of just leads into the utility application. A utility application covers how an invention works. And when people think of patents, typically they're thinking about a utility application. So as I said, after that year, you have the ability, or you make the decision whether you file the utility application or not. Actually, you know what? Now that I think about it, there's one other thing about provisionals. Another reason people file the provisionals is within that year, typically they're looking for licensing opportunities. And as I mentioned before, patents are expensive. There's the fees that you have to pay the patent practitioner and the fees you have to pay the patent office. So within that year, typically what a lot of people are doing with their provisional, they're going around to looking for various licensing opportunities. And they're doing that so that if they're able to find one, then the licensor will help them with the additional fees that they'll have to pay to finally get the patent issued. So I probably should have mentioned that before. So that's the reason some people would file a provisional first, because you actually do have the option of filing a utility without filing a provisional application. It's just that a lot of people tend to want to file the provisional first and then basically look for help with funding the rest of the application. So back to the utility application. So as I said, the utility application has to be fully supported by the provisional application, and essentially it has to be in a pretty good, it has to be in the format that the patent office wants. Provisional applications actually aren't reviewed by the patent office when they're filed. They will be reviewed when you file a utility application, because they want to make sure that the utility is fully supported by the provisional. And as I said, utilities are for how things work. So they require a very logical and easy to understand what's called a specification, basically going through the problem of what the invention is trying to address, how the invention addresses that problem, and the end of the application is actually what's called the claims. And that essentially is what your invention is. Typically, for a utility application, you get 20 claims, 3 of them independent, and then 17 of them are independent or are dependent. And when I say dependent, that means they depend on one of those independent claims. You get 20 of them. And then after every claim that you claim after those 20, you have to pay extra money for it. So that's that for utility application. The other type of application is what's called a design patent application. Design patents cover how something looks as opposed to how something works. Typically, people really want to get the utility application, but if they think that they don't have a really good shot at getting utility, they'll file for a design patent. And they're not as in-depth really as a utility application is, since they only cover how something looks. So essentially all you really need to have is your drawings in the proper format, basically showing what your invention, how it looks in all its embodiments, and that essentially is the application. Design patents typically don't take as long to get as utility applications. I think I mentioned 3 years. When I said 3 years, that's typically for utility applications. For design patents, they typically take about 1 year. And then not only that, but design patents typically aren't as expensive. If you're probably going to be paying a patent practitioner about $1,000 for a design patent, but for a utility application, you could be paying up to $10,000 for that. And then another difference between utility and design is the time that they're good for. So something I should mention is that patents aren't good forever. They have expiration dates. Utility applications are good 20 years after you apply for them. So after the 20 years is up, that's it. Anyone can make your invention, and they wouldn't be infringing on your patent. For design patents, they're good for 14 years after the design patent has been issued. And so after that 14 years, that's it. Anyone can design and sell your invention without infringing on your patent. So you have to keep that in mind. Next thing. All right, you decided which type of application you're going to file. It's going to be you're going to file a provisional, and then look for licensing opportunities, and then file the utility application. Are you going to file a utility application right away and get started on the whole process of getting that issued, or are you going to file a design patent? You've made that decision. Now you have to get drawings done. Typically, there are a number of companies out there and draftsmen that can file patent grade drawings for your application. The prices vary. Some charge as little as $10 a sheet, and some charge as much as $100 a sheet. It all really depends on the complexity of your invention. It also depends on how many drawings you're actually going to need for your invention. There's a bunch of different factors that will affect the price. So once you've done all these other things, you've had your prior art search done, you've decided what type of application you want to file, you now have your drawings ready. Now it's time to actually draft the application. So that's where your patent practitioner typically comes in. A lot of patent practitioners will outsource the prior art searching, and they may outsource the drawings as well, but they'll be the ones that actually draft your application. And of course, they'll use the invention disclosure form that you provided. They will use the drawings that the drawing companies provided. They will refer to the prior art search to differentiate your invention from other inventions that already exist. And they will use all that information to then draft the application. And once they've drafted the application, obviously they'll send it to you to look over to see if it's what you're expecting. And then once that's done, then they'll actually file the application with the patent office. Typically what they'll file with it is obviously your application, and then an application data sheet, which basically gives more information about yourself and also about the patent practitioner. And they may file a power of attorney, which basically just says that you, as the patent practitioner, is your representative on your behalf with the patent office. And let's see, and also they'll pay the fees. So provisional applications cost, for small entities, they cost about $130 to file a provisional application. For the utility application, I believe it costs about $730 to file. And then for design, I think it's about half of that. And so those are the fees that you're paying to the patent office to basically file your application. Okay, you think that's okay. Now it's certainly not over. So now you're going to hear something back from the patent office. You'll get your acknowledgement that you filed the application. If anything was missing, you'll be contacted by the patent office also, is to say if anything is missing from your application, then you have some time to be able to make those changes or amendments. But then essentially the next big step is getting an office action from the patent office. So I mean, it's possible that after you file your application, you wait some time, a patent examiner looks at your application and decides that your patent is issuable, and they may just issue it right away. But what typically happens is when patent practitioners file applications, they try to basically take as big of a bite of the apple as possible. When I say that, I mean they try to they'll have specific claims on your invention, but then they'll also try to have broader claims to see how much they're able to get for you, essentially. Because essentially the broader your claims are, the easier it is for others to infringe on it. So then essentially the patent examiner will issue objections or rejections essentially on the claims that you make, specifically the broader claims, and that will come back to you come back to the patent practitioner in the form of an office action. The office actions are typically based on novelty and obviousness. So if the patent examiner thinks that some of your claims are not novel, they're not new essentially, and that they're infringing or that they're the same as claims from other inventions that have already gotten patents or ones that have already been applied for patents, they'll issue novelty rejections. If the patent practitioner thinks that some of the claims from your invention are obvious, meaning that someone that's skilled in that field could obviously have made your invention based on perhaps combining different inventions together, essentially to get your invention, then you'll get a rejection based on obviousness. Essentially, then that's when your patent practitioner is really going to get put to work, because now they have to respond to this office action. So the patent examiner will say whether your patent's been rejected based on obviousness or novelty. They'll say which claims have been rejected, and then it's up to your patent practitioner to then try to convince the patent examiner to allow your patent application to keep going forward. Sometimes they'll try to, sometimes the patent practitioner will call the patent examiner and talk to them and see. So for instance, if I make this change to this claim, will it be allowable? And then basically a dialogue will be developed between the patent practitioner and the patent examiner. Sometimes the patent practitioner will make changes to the claims to make them distinct and make them different from basically the rejections that the patent examiner originally came with. Sometimes they'll just try to argue that the rejections were incorrect and that the patent examiner shouldn't have rejected them based on either novelty or obviousness. I mean, it all depends on what the patent practitioner thinks of the rejections, and obviously they'll be in contact with you, the inventor, the entire step of the way to let you know, keep you abreast of what's going on with your application. So then once the patent practitioner responds to this office action, typically you get about 3 months to respond to an office action. Then it's back in the examiner's court to decide whether the response to the office action was persuasive enough to now allow the application to go forward. Another issue I should bring up actually is, in some instances when a patent practitioner files an application, they may get a restriction requirement from the patent examiner, and that's basically what the examiner is saying is that you've claimed more than one invention in this application, and when you're filing an application, you're only allowed to claim one invention. That's it. If you want to claim other inventions, you have to file other applications, and that kind of makes sense because these things cost money, as I mentioned, all the fees. So if people had the option of just filing a whole bunch of different inventions in one application, they certainly would do so to save the money. But the patent office says, no, you can't do that. Just one application, or one invention per application. So you may get what's called a restriction requirement, which requires you to then pick one invention from the application you filed. And then when you do that, you pick one, and then the other inventions that have been highlighted in that application, you have the option to file applications for those inventions, and you'll get the filing date of the originally filed application. So you definitely have that option. People try that all the time, see what they can get away with, and sometimes they're able to, and sometimes they're not. But you never know until you try, right? So now you've gotten the response from, hopefully now you filed your office action, and then, as I said, it's in the examiner's court to decide whether your response was persuasive enough. And if so, then they will issue an allowance of your application, and your patent will be issued. But there's a fee for that. There's an issuing fee, and I think for small entities it's about $480, and then for larger entities it's double that. So that would be what, $960? Yeah, $960. So there's that. But then if your application or if your response was not persuasive, then the examiner can issue another rejection based on novelty or obviousness, and then you have to respond to that. So essentially, it's a back and forth between the patent practitioner and the patent examiner to get it to the point where it's allowable. Now, typically, every time that your patent practitioner is corresponding or writing a response to an office action for your invention, they're charging a fee. And the fee can range from $500 all the way up to $1,500 per correspondence with the patent office. Now, of course, all of this money is adding up, and you're kind of have to really look into whether it's even worth it to continue on the path of getting the patent. You really have to weigh the pros and cons of it. So hopefully now you're at the point where you've gotten you've basically convinced the patent examiner that your patent is going to be allowed and issued as a patent. That's great. Now, so you've paid the issue fee. Now you're supposed to get your patent, and you do. Congratulations, you've gotten a patent. It's still not over, because now there are maintenance fees. Once your patent is issued, at 3.5 7.5, and 11.5 years after your patent has been granted, you have to pay what are maintenance fees. And the fees actually go up, you know, per time period. So the 3.5 year maintenance fee is not as expensive as the 11.5 year maintenance fee. And so I mentioned a whole bunch of fees already: the maintenance fees, the issuing fees, the filing fees. There's prior art search fees. There are the patent drawing fees. It's a real the costs add up, and as I said, typically that's why people file the provisional applications, because they want to look for licensing opportunities to help basically offset all these costs. I mentioned earlier that it can take up to 3 years to get a patent. So it's not like you just get you apply and then that's it. You have a patent. And something else I really I would be remiss in not mentioning is that there are thousands and thousands of patents out there, and even more that have been applied for patent applications out there that haven't issued as patents yet. But did you know that only a small percentage of those actually ever end up being monetizable? Obviously, you came into or you should have come into this whole process thinking, I want to make money off of this patent. So you really have to give a lot of thought as to whether you want to spend the time, the effort, and the money, especially the money, in going forward with applying for a patent when you know only a small percentage of them ever become monetizable or basically ever make money. And it comes back to that same point of applying for a provisional and doing a prior art search before you even engage a patent practitioner. You really want to know what the market is out there for something that you want to, for an invention that you want to see become a reality. I mean, is there a need? Do you think that are there customers out there that would be willing to pay for your invention? All of this you have to really take into account. And the crazy thing is you have to take all of this into account without publicly disclosing it. So when I mention licensing, oftentimes what people will do, I mean, people see those shows like Shark Tank where people go on there with their invention ideas, and typically they are patent pending. When they say patent pending, typically what that means is they filed a provisional patent already, and they're now looking to license, and then hopefully have someone help them with all the additional costs, the patent practitioner costs, in addition to the patent office costs. You've done all this work, and you really then need to really figure out whether it's even worth it to go to these even licensing places. Because another thing about these looking for license opportunities, especially if you're working with angel investors or venture capital firms, is that they don't want to sign non-disclosure agreements. So then you really have to be very specific, or not actually the opposite of that, non-specific on what you disclose to them, because you don't want to publicly disclose everything there is to know about your invention, because then you're on the clock. Once you've publicly disclosed your invention, you have a year to then file an application. And if not, then anyone can. I think that's all I really wanted to say about filing an application, get the process for getting a patent. I mean, as I said, it starts with an invention disclosure form, and it goes all the way down to hopefully you getting the patent and then paying maintenance fees. But as I said, there are a lot of fees that are involved, both patent practitioner and through the patent office. You have to take all this into account when you're really deciding whether it's even worth it to file an application. And any patent practitioner who says that they can get you a patent no problem, they're lying. They can't possibly know that. It's all opinion. They'll try their best to convince the patent examiner that your invention is worth getting a patent for, but you always have to keep abreast, or you always have to keep in mind that obviously the examiner's a human. You may not be able to convince them, and if so, do you pull the plug on it? Is it worth the money to continue going on with the process? These are all things you need to take into account and keep in mind. Yeah, as I said, that's all I really have to say about that now, about patents and getting them. Hopefully this information was useful. If you want to know more about it, or want to just have a consultation maybe, or even just pick my brain as to whether it's worth it for you to continue on with your patent idea and pay all the money to get your patent issued. You can contact me. You can get to my website, which is Neil I. Thompson. That's NeilIThompson.com. And you can contact me by email at neil@neilithompson.com. I could possibly send you an invention disclosure form just so you see what it looks like. It really helps to really flesh out your idea, and when you see it in black and white, basically with all the questions that I've asked on the invention disclosure form answered, that hopefully can help you even determine whether this is an idea that's worth going forward with. So hopefully, as I said, this information was helpful. Again, thank you to the Boyce Watkins community for giving me the opportunity to talk about this. Dr. Watkins is providing a great service with all of his platforms, with his YouTube videos, which I've been following for a number of months now. Very great information. For those of you that don't take advantage of all of it, I highly suggest you do. The Facebook live streams, the Periscope streams, the YouTube videos, the paid programs, because as he says in his videos, everything can't be for free, because they're paying people to provide the services for us to all benefit from. And I mean, if you didn't pay them, well, then the services would go away, and then we all would really be upset. Again, thank you all for listening. Hopefully this has been useful. Have a great day. Happy holidays.